Hi, everyone. Thank you for joining today's webinar presentation, How USPTO Examiner Type Affects Patents. I'm Allie Morton, Product Marketing Manager at LexisNexis IP, and I would like to just cover a few things before we get started today. During the webinar, please feel free to submit questions using the questions feature in the control panel. Also in the control panel, you will see a handout section. This is where you can access files pertaining to today's webinar, including the webinar slides. A follow-up email of the recording from today's presentation along with the slides will be sent out later today. Now I'd like to introduce our presenters. With us today, we have Megan McLaughlin, the Product Director for LexisNexis PatentAdvisor. After graduating from Harvard Law School, she worked as a patent attorney at the law firm of Nutter, McLennan & Fish. Her technical focus reached into a variety of industries, including medical devices, the food industry, software, printers, and biotech. Also joining us today is Dr. Michael Sartori, a partner from Baker Bott's Intellectual Property Department. As a registered patent attorney, he focuses his practice on patent prosecution, patent portfolio counseling, and patent litigation. Prior to joining Baker Bott's, Dr. Sartori served for over a decade as chair of the Patent Prosecution and Counseling Group at another Am Law 100 firm. And last but certainly not least, we have Jean Quinn. Jean is the founder of IPWatchdog.com, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Jean has been named one of the world's leading IP strategists by IAM Magazine. Thank you again, everyone, for attending today's presentation. And with that, I will turn it over to you, Jean.
Great. Thank you very much, Allie. And thank you all for being with us here today and spending a portion of your day with us to talk about this important topic. You know, we talk about examiners a lot, but we probably can't really talk about them too much. As you all know, or as you probably should know, examiners play a critical role in issuing patents, and the examiner that you get is, well, there's no other way to say it than just so fundamentally important to the success of your client's application. And there is a bit of a lottery that goes on at the office. You know, sometimes you get a good examiner, sometimes you get a bad examiner, and a lot of attorneys that we talk to think that there's nothing that you can do, but there are things that you can do. And that's really what this series that LexisNexis IP has put together and we've been working on over the last several months, and we're going to continue working on throughout the summer, is going to talk to you about the problem, quote unquote problem. The different examiners go at different paces, at different speeds, have different allowance rates, and what can you do and how can you navigate to the advantage of your client? So we have another exciting discussion. I think it's exciting because, you know, I'm a patent nerd, but you all know that. So let me bring in our panelists here and get their preliminary thoughts on this topic before we go through the slides. We have a bit more slides in this webinar than we normally do because we have data. We want to give you some data and some interesting data that Michael has put together. But Megan, let's start with you before we go to Michael. And Michael, I'll ask you the same question. What is it that you'd like folks to have in mind as we start the conversation? Is there anything that you, from maybe a big theme, or what is the focus that they should be thinking? How do you want to frame the discussion we're going to have? Megan.
Yeah, so I mean, I think anybody who's practiced at the patent office is aware that different examiners behave differently. But I think the crucial point that'll come through from Michael's research is that this will affect you. If you're practicing at the U.S. Patent Office, examiner variability is affecting you, even if you don't think it is, because when it comes to U.S. prosecution, really it's the examiner driving the car. The examiner that you get has a huge impact on your outcomes, and so I think it's important to be aware of that. And hopefully this webinar will give you some practical tips for dealing with this variability.
Yeah, great. Okay, thanks, Megan. Michael, how do you want to frame the discussion? I know much of what we're going to talk about here today comes from an article that you have co-authored, and it's a part of a series as well. So what do you think?
Yeah, that's right. Thanks, Gene. So this is Michael Sartori. I'd like to thanks everyone for listening today to the webinar. I think we have some really interesting and exciting things to share with you. But we've been using PatentAdvisor database for some time, and really appreciate the kind of categorization of the examiners, as well as kind of the assortment of the data available here. But really find it really useful in making strategic decisions during patent procurement process at the USPTO, and really believe it can help in reaching resolutions sooner in the life cycle of a patent application. In doing so, you can, we believe, conserve budget on each application, and also build a patent portfolio more cost effectively and more efficiently. Every patent portfolio has a budget, and to the extent you can stretch that budget to get better results or faster results, the resulting portfolio truly benefits. Anyway, but I think using the examiner statistics like we're going to talk about today is a great way to achieve this for your patent portfolio. So, Gene?
Okay, great. Well, thanks for that. My thoughts, I've already kind of shared my thoughts. This is very important stuff, and I don't want to take any more time because I want to make sure we get all the way to the end of the presentation if we possibly can. We have a lot of slides, so Michael, why don't you just kick us off and we can get going?
Okay.
Yeah, so I'll go ahead and get us started. I want to set the stage.
Oh, I'm sorry, Megan.
For...
I forgot.
Okay.
I apologize.
That's okay. I want to set the stage for Michael's research because it's all based on the way that we measure patent examiner behavior in PatentAdvisor. So examiner analytics are everywhere now. And probably the two things that people look at the most, and understandably so, are the examiner's allowance rate and how many office actions it takes to get a patent. These statistics are easy to get. They're everywhere. But they can really be misleading. And this is what we realized after a few years of propagating these kinds of statistics. So if you click through, Michael, for one, they don't incorporate pending applications. Allowance rate is only measured based on disposed patents, patented and abandoned applications. So first of all, it's a lagging indicator. If you've got a new examiner, we all know the patent life cycle is 3 to 5 years. It could be 3 to 5 years before there's a meaningful number that's going to help you understand a new examiner. And also, it penalizes for abandonments, which makes some sense, right? If an examiner is continually difficult, incredibly hard to work with, over time you'll start to see abandonments accumulating. But it takes a while for that to happen. And not all abandonments are because the examiner was difficult. People abandon applications for all kinds of reasons. So if you dig in, and this is a specific examiner, if you dig in a little bit deeper into this examiner statistics, you'll find a very different picture than what you would originally think from just looking at their office allowance rate and office actions to issuance. So if you dig down, the first thing you see is that this is a new examiner. They've only handled 174 applications total in their tenure. So they're pretty new. They don't have, there's a little bit of a small numbers problem with allowance rate. And then moreover, if you start looking into their pending portfolio, they've got 69 pending applications and an average of 3.3 office actions just in those pending cases. So yeah, sure, they were able to bring some cases to issuance in 2.6 office actions, but there's a significant amount of churn that's happening with the pending portfolio. And you would never see this if you just looked at the headlines, if you just looked at allowance rate, office actions to issuance. You really have to dig. So if you go to the next slide, Michael, what we realized was there's a better way to think about this. And this is based off of some research by Dr. Shine Tu from the University of West Virginia. What he discovered a few years ago was that looking at the ratio of office actions to grants across the examiner's portfolio, taking that ratio, it is incredibly predictive of how that examiner is going to operate in the future. That one ratio tells you so much more about the examiner's behavior than all of the other statistics I just showed combined. And he wrote a paper about that you can look into and see. But really what he found is that this ratio is a fantastic indicator of how the examiner operates. And when I say total office actions to total allowances, I mean across the portfolio, right? Not in any given case. So like if the examiner comes into the office one day and he's got 10 cases on his desk, and he pulls out one and he rejects it, he pulls out the next one, he rejects it, and then he pulls out the third and he allows it, that would be an ETA of 2. So in general, when this ratio is high, in particular over 6, we consider that to be an incredibly slow, inefficient patent granting examiner. If it's between 0 and 2.5, we categorize that examiner as green, meaning that they're incredibly efficient. They're granting patents quickly, maybe between 50 and 100 patents per year. And then yellow is everything in between. And part of it, there are many reasons for the magic behind this metric, but just in short, one of the reasons that it works so well is it includes the pending portfolio. So you can get some information about an examiner even before they've allowed, after they've allowed their first case, we can tell you something meaningful. It does also factor in how long the examiner's been at the patent office. So it's more than just that ratio. We've done a little bit of smoothing to account for situations, for example, where an examiner's behavior is changing or where an examiner is new. And finally, and I think the most important point, it's driven by the examiner's behaviors. So it's literally, what is the examiner doing? Are they writing rejections or are they writing allowances? And so we feel that it's a fair way to measure them. And so from Michael's research, this is how he's dividing the examiner core into red, green, and yellow based on this ETA metric. So I'll hand it over to Michael now to talk
Megan,
about
before
his research.
Before you do that, can I ask you a question there just for clarification purposes?
Sure.
Now, it's my understanding that with the red examiners, the reason that this is a really interesting way to look at it, just aside from just always looking at the allowance rate, is you may have certain red examiners that have a fairly reasonable allowance rate. It just takes them forever to get there, right?
That's right. Yeah, I'm glad you asked that question. Yeah, go ahead, Gene.
And the reason that that's relevant is, we all know that there are some examiners, and there's always the minority that makes it the bad name for the majority, right? So I don't want to make it seem like this is every examiner at the office, because it's not. But there's a certain number of examiners that are going to force you to file at least one, maybe two RCEs. And then they're going to allow you, after they get enough quota time out of the case, well, that person becomes a red examiner pretty quickly.
That's right.
But they may have a pretty reasonable allowance rate, and so you think you've been assigned a really decent examiner, and it's like you're just dealing with somebody that's frustrating, and this explains that.
That's right. And actually, I'm glad you asked that question, because I forgot I wanted to talk about the next slide, which compares allowance rate to ETA. So this is a question we get a lot. Well, isn't the allowance rate basically going to be the same as ETA? I mean, over time, won't enough cases accumulate that allowance rate will reflect the ETA? And yeah, allowance rate tracks the ETA. It's very, if your examiner is very much in the green zone for ETA, they're going to have a high allowance rate, right? I mean, if they're only issuing one rejection for every allowance they issue, of course they're going to have a high allowance rate. And same at the far end. If they're issuing 12 rejections for every allowance, okay, their allowance rate's going to be lower. That's true, but there's a lot of noise.
Yeah,
you can see particularly
the noise in the red. I mean, you see some that are well into the red that have an allowance rate over 60% at that one dot over there. And some of them are over 70% and they're well into the red. I mean, and that's what makes this metric so meaningful, because you may get a patent from these people, but it may take many years and a lot of money in prosecution and a lot of agita and a lot of claim amendments. And, so if you can steer away from red, you want to steer away.
That's right.
And you can. I mean, not always, but there are tactics.
Right, and we'll talk about some more of those when we get to the end of the webinar.
Yes.
But for now, I'll turn it over to Michael to talk about the research that he's done using this ETA metric to measure examiner behavior.
Sure. Thanks, Megan. As Megan noted, patent procurement at the USPTO is affected by the type of examiner, as she's shown. And at Baker Botts, we have been using the PatentAdvisor database for some time, and we became curious as to whether the dynamics that we were seeing in the database were the same all of the time, or changed over time, or what the story was, for this. So we decided to undertake a study of the database by collecting and analyzing over a decade of data. And then with the help of several folks at Baker Botts, including Matt Welch, who's a co-author of the articles, who led the effort, Chris Hong, Brendan O'Callaghan, and Dr. Lynn Cow, we gathered the decade plus of data. and we decided to focus on 8 non-design tech centers at the USPTO and disregard the design tech center due to its outlier statistics. Anyway, we collected many metrics that span the life cycle of a patent application, and this was a very intensive effort we undertook. So based on our research and results, we're publishing a 4-part series of these articles talking about this in Law 360. The first part was published on May 15th, and the second part was published earlier this week on June 16th, a couple days ago. And the third and fourth parts will be published later this summer. Anyway, this webinar focuses on the results in the first part, namely the USPTO examiner type and tech center distribution, as well as an interesting result that we uncovered that few allow many and many allow few. So let's talk about the USPTO examiner type and the tech center distribution over the decade plus of data that we have. We have a poll question here first, Allie. Okay, over the past decade, which examiner type do you think there is the majority of at the USPTO? So please select one of these. Is it green examiners, yellow examiners, red examiners? Maybe yellow and red are about tied, green and yellow about tied. What do you think? So Gene and Megan, I know you guys know the answer, so you're not allowed to say what this is.
Very interested to hear what other people think, though.
I think
Yeah,
so
I'm
too.
looking at the numbers come in, and they're a little bit all over the place. There is a clear favorite in the clubhouse here.
Okay, there we go. So the results are in, and we have the most people said it was yellow examiners make up the majority, but some think green or red, maybe a combination had some as well. So based on our results over the past decade, the answer is, oh, let's see, you want to release the poll there? There we go. And the results are, it's actually yellow examiners. So over the decade plus of data that we have, the number of green, yellow, and red examiners for each of the 8 non-design tech centers, here they are. So this figure illustrates the percentage of those examiners for each year for those 8 tech centers, and the total for each year is 100%. So if you like add up the red, green, yellow on each of the years, you'll find those are 100%. And over the period, you can see that the percentages of green and yellow examiners have diverged from approximately 40% at the beginning of the decade of data to approximately 35% and 45% split now in 2019. Also, you see the percentage of red examiners has been relatively constant over the years at around 20%. And so what I really find fascinating about this, Gene and Megan, is really the consistency in the percentage of each type of examiner over this period. So while the calculation of examiner types has remained the same with the LexisNexis, but the numbers of examiners have shifted over the decades as people kind of come in and out, and you'll see the numbers fluctuate in another slide or two down here. But these percentages are really pretty consistent. The red examiners are about the same, and the green and yellow examiners are about the same, at least especially for the last 5 years or so.
Yeah, that is a really interesting observation, particularly when you consider that I think there's fairly high turnover in the examination core. New examiners are more likely to be red.
Yeah.
Yeah.
Well, another thing, some of the folks that they're examiners there, you know, that they don't make their quota initially, then they get cut, and you know, even people that get very close to that quota mark and that want to stay at the office get cut, and rather than trying to make them more efficient, and so there is unfortunate turnover rather than investing in new examiners to make them better. But you know, that's a different webinar for a different day, I think.
Yep.
Yeah, well, I knew that could be part of the reason for the high amount of red examiners recently, but I guess I'm not aware of what was happening at the USPTO in 2009, but maybe the turnover was just as high then.
Well, it is, you know, and I think, you know, it was interesting with the poll because, you know, your perception on what is the office made up of is almost certainly where are your applications going? You know, if you're dealing with certain art units in 3600 a lot or certain art units in 1600 a lot, then your perception is that everything is red at the office. what is really interesting is very few people said everything is green at the office, although there are certain things that you can file that you are virtually guaranteed to get a patent if you can navigate to those art units. So maybe what it is it's just knowing how to get to those art units, and maybe, so maybe we'll teach you all a few tricks here.
Okay, so the next slide here kind of summarizes the decade plus of data for these 8 non-design tech centers. So the first column is the tech center number, and the last column lists the type of inventions that each tech center examines. The second column is the average percentage of patents that each tech center has issued over all 8 tech centers. The third column is the average number of examiners over the time period for each tech center. And the fourth, fifth, and sixth columns are the average percentages of green, yellow, and red examiners in each tech center over the time period. So for the average number of examiners in the third column, tech center 1600 has the least average number of examiners, and tech center 2800 has the most and is more than double than the number in 1600. Also, as you look at the percentage columns vertically, each column totals 100%. And an average value for a particular cell would be 12.5%. So as to the percentage of the examiners of red, yellow, and green, tech center 2800 has the highest percentage of green examiners at 32%, and the least percentage of red examiners at 5%. And then tech center 3600, which handles the business method inventions, has the highest percentage of red examiners at 23%, which goes to what Gene was saying earlier about that tech center. Also, the amount of yellow examiners are a bit more evenly distributed over these tech centers. And this is the averages for the data that we analyzed. Okay, next, this figure illustrates the distributions of the actual number of examiners for each tech center for each year of the data that we collected. As you can see, over this time period, tech center 2800 had the most examiners and had more than twice as many examiners as tech center 1600, which had the least number of examiners. And tech centers 2800 and 1600 form bands around the other 6 tech centers, which is kind of interesting. And of note here, tech center 3600, which has the largest number of red examiners, had the 3rd largest number of total examiners in 2019, which is kind of interesting. Next, we looked at the number of patents per tech center. So this figure illustrates the distribution of the percentage of patents issued by each tech center in each year. For each year, the values at 100% kind of as you go through each year vertically. So as you can see here, the percentages of the 7 tech centers are clustered in the range from 5% to 15%, and the percentages of the outlier tech center 2800 really swamped those, and they've decreased from a bit over 30% in 2009 to just less than 25% here in 2019. Also, I'd like to note that while tech center 3600 has the largest number of red examiners, tech center 3600 also was tied for 3rd in 2019 for the percentage of patents issued each year, which I think Gene has noted in some prior webinars that even though 3600 has a lot of red examiners, there's actually some pockets of examiners issuing patents, a lot of patents.
Yeah, actually, if you look at 3600, it's really a mixed bag, because some of the worst art units with the lowest allowance rates are in 3600, and then on the complete flip side, some of the highest allowance art units are in 3600. So it is Dr. Jekyll and Mr. Hyde in 3600. So just getting assigned to 3600 is not necessarily the kiss of death. You have to really look and see which art unit you've been assigned.
Yep.
The thing that strikes me the most about the past few tables that you've shown is still just how little that's changed. I mean, there's some movement. It looks like 2400 is moving up a little bit, but particularly when you consider how much has happened in the past 10 years. I mean, and how the size of the patent examination core has doubled. It's surprising to me how these percentages have largely stayed the same.
Well, we have a question on that point, Megan, about how come the AIA did not make a bigger difference in these numbers, along that, you're surprised as well. Rainier asked that question from the audience, and I mean, my thought on that, I have a couple of different thoughts. One is at the time with the AIA, remember, that also came in around the time when we were still feeling the after effects of the Great Recession, and a lot of examiners who ordinarily might have put in 2, 3, 4 years and then left were not leaving because there weren't as many jobs. So they're, they were moving forward, and many of the cases they were looking at were still being examined under the old law until only over the last couple years, really. They had a tremendous backlog of old cases. So that may be some of what, but I mean, I don't know whether you guys have any thoughts on that.
I'm on Megan's side with this one. I'm surprised with the change in the law. The big ones like the AIA and some of the big cases here that you don't see these affecting this trends, and that I think it's really dramatic that that these percentages are really pretty consistent, shockingly consistent. I think through all these years.
Yeah, I mean, the other thought that I have is, and this is maybe a little bit more inside baseball, but I think it really does affect this, is a lot of the SPEs really have an outside influence on art units, and they are the ones that are in control of the new examiners. New examiners don't issue patents; they examine patents, and then it's the SPE that is going to issue the patents. And the SPEs don't usually move a lot. I mean, there's been a lot of movement lately in certain art units because they need to find SPEs in certain areas and move them around. But in some, like 3600, some of those SPEs have been there forever. In 2800, some of those SPEs have been there forever. And so the art unit really develops a culture, in a culture of either allowance or a culture of or denial. And I think that permeates. And I've had a SPE tell me one time that in conversations relating to when Director Kapos was there and he was pushing to have more patents issued in a more friendly environment. No uncertain terms, quote, "I will be here longer than anyone on the 10th floor." And the 10th floor, for those unfamiliar, is the director's floor. So there's a culture in these art units that go beyond the culture at the patent office.
And that's actually a pretty good segue to the next slide here, Gene. We didn't keep that up at all. That's actually pretty good. So what we did next is we explored the percentages of the green, yellow, and red examiners for each tech center. And this slide shows the distributions of the examiner types over 5 tech centers, namely 1600, 1700, 2100, 2400, and 3700. And I think what's really interesting, as Gene kind of mentioned there, is that these 5 tech centers exhibit a similar pattern over the decade plus of data from 2009 to 2019. What you can see here is that each of these tech centers has nearly half yellow examiners, and the remaining green and red examiners at around an even 25%, or at around 30% green and 20% red. And I think this is really fascinating. I think it goes to, the tone being set by the head of the tech centers, and then also by the SPEs within there, but just the consistencies of these numbers over this time period, I think is just really, really interesting. And there are 5 tech centers, 5 of the 8 ones, have this similar pattern.
Yeah.
It really lends. Go ahead, Shane.
It just holds. It holds for the whole decade.
It lends credence to the story that we've been telling in PatentAdvisor for a long time, which is that the thing that impacts your prosecution maybe more than anything is the examiner to which you've been assigned. I think we'd like to think that there's all kinds of external influences on whether a patent's going to get allowed, and certainly there are. When the law changes, obviously it can get easier or harder, but who your examiner is, it's a steady, it's kind of the backbone.
Yep.
Yeah. And we have somebody ask,
go ahead, Gene.
How to talk a little bit more about how an SPE can influence the examiners under them. And what it basically boils down to is the SPE is responsible for mentoring and tutoring the junior examiners who don't have signatory authority. And the junior examiners do all the work, and then they go to the SPE and they lay it out in front of the SPE and here's what I found, here's what I think, this is the rejection I'd like to make, this is what allowance I would like to make. The SPE will look all over it, and the SPE will decide, okay, you need to go back and search again, we can't allow this claim is too broad, okay, you can allow this claim, so the SPE is, and it's much the same way as you would imagine mentoring would go on in a law firm, where you're on the other side, somebody is drafting the claim, the partner's going through and saying, okay, well, it needs to change in this way. The SPE is mentoring the junior examiner. Now, if you get a SPE that is works for the patent granting authority, then the SPE is going to be leaning in that direction. If you get a SPE who fundamentally thinks they work for the patent denial authority, then they're always going to send that junior examiner back to do more searching and to reject. Now, I've heard in some of the low allowance R units over the years from junior examiners that they're told to just come up with rejections, just make a rejection up. Now, you can guess what art units those are, but and this is the minority, obviously, in the patent office. The patent office works extraordinarily well. We're talking about the fringes on both sides, where there's some art units that allow everything and some art units that reject everything. But if you look at these graphs, the patent office works like if you look at 1600, it's a bell curve. You look at 1700, it's a bell curve. Look at 3700, it's a bell curve.
Pretty fascinating. Pretty fascinating. So these are the 5 of the tech centers, and then to be any good statistics, you have to have some outliers. So we've got 3 tech centers which don't follow this trend, which are really quite interesting. So these remaining 3 tech centers have dissimilar examiner type patterns from the other 5 and from each other. So for tech center 2600, the percentage of green and yellow examiners were the majorities, with similar percentages at around 45%, while the percentages of red examiners is around 10%. Now for tech center 2800, the green examiners are the majority and by a considerable amount, hovering around 70%. In addition, as we showed earlier, tech center 2800 contributes the most to the number of patents issued each year by the USPTO, which is due to the significant number of green examiners. The percentage of yellow examiners is around 25%, and the percentage of red examiners is around 5%. But compared to the other tech centers, tech center 2800 has the greatest number of green examiners percentage-wise and the least number of red examiners percentage-wise. Now over to the right side of your screen, finally for tech center 3600, which has a lot of business method inventions, examines business method inventions, the percentages of the examiner types have been range-bound over this whole time period between 29% and 38%. And while the number of yellow examiners has been greatest for most of those years, the number of red examiners overtook the number of green and yellow examiners in 2018. So the previous slide, we saw 5 of them have the 45 or 50% yellow and a 25-25 red-green split or 20-30 red-green split. These 3 ones have such dissimilar patterns. But the dissimilar patterns are also quite consistent over the years, except for the range-bound one. There's really, I think, a bouncing back and forth as to which examiner will take control, like type in 3600.
And I hate to keep harping on this, but I just have to, because one of the questions that somebody asked was, what's been the effect? What is the effect of 101 changes, which you would expect to see in 3600? I mean, granted, 3600 is diluted by some of the transportation stuff, so it's not just computers, software, business methods. But you would expect to see, some significant rise in the percentage of red examiners in 2014. But there's only a teeny bit, and then that jump in 2019, when we got the 2019 guidance that actually made things a little bit better, is very surprising to me.
Yeah. What I would just say on this is I'd like people for later on to remember that 2600 and 2800 are good art units to be in. 3600 for certain computer stuff is a bad art unit to be in. Look at the high number of red. And that will become relevant in a little while.
Okay, so let's see. So let's go ahead and let's transition to the next topic, which is few allow many, and many allow few. So we have a poll question here. So over the past decade, which examiner type do you think issues the most patents at the USPTO? Is it green, yellow, red, some combination of green and red are about tied, or yellow and red are about tied? What do you think? What do you think? And Gene and Megan, you're not allowed to vote again.
Well, this is much closer. People are.
Okay, the results are in. And here we have, most people think it's about almost 45% think it's green, 43% say it's yellow, and some think it's tied between green and red. But if you still think it's kind of red, this is very interesting results. Okay, so let's go to the next slide here. And this is a refresh. We saw the slide earlier. This is just to remind you of who the overall examiners are and what they are. The yellow is at 45, green 35, red 20. But who's allowing the most? It's actually the green examiners. The green examiners allow the most, not the yellow, but the green ones. So this figure illustrates the percentage of U.S. patents for each type of examiner issued over the time period, the decade plus data. As you can see, the percentage of all U.S. patents that were issued by green examiners is over 50% and is more than those issued by yellow and red examiners. Also over this time period, although the differences in percentages of U.S. patents issued by green examiners and yellow examiners has narrowed, the average percentages are approximately 60% and 35% respectively. In contrast, the percentage of U.S. patents issued by red examiners has remained really around 5%. And this figure, I think, really shows the dominance by green examiners over the time period in issuing patents, and is contrasted with the consistently low amount of patents issued by the red examiners.
Michael, can I ask you what do you think it means, if anything, of the slight decrease in the share of patents granted by green examiners? So we know that the number of green examiners proportionately is fairly constant.
It is.
But we see their share of patents decreasing slightly. Do you make anything of this, or?
I'm going to flip back to the previous slide, Megan. So as you can see, the number of green examiners does decrease slightly over the years from 40% to about 35. The yellow has increased from 40 to 45. And so I'm going to go to the next slide then. I think if you see that widening of that gap there, I think translates to the narrowing of the gap on this slide. I think it's just a fact that there's just a lesser number of those examiners over that time period.
Yeah, but the red examiner stays pretty flat around 5%.
Shockingly flat, right?
Yeah, you don't want a red examiner.
Don't want a red examiner, don't want a red examiner, So, yep. So combining, combining the data of the last two figures, we see that 35% of the examiners, the green examiners, allow 60% of the patents, and that 20% of the examiners, the red ones, allow only 5% of the patents. So what we have here is a thesis of few allowing many, and many allowing few. And this kind of goes back to the study that Megan alluded to earlier, that the whole ETA theory is based on. Like this pans out over this decade of plus of data that we looked at. So what we did is to try to hope this isn't too esoteric. What we did is we tried to bring this idea further home. We wanted to combine the data of the percentages of the examiner type and the data on the percentage of the patents issued and try to come up with some sort of measure. So to do this, consider the concept of a quota for each examiner type. So as many of you know, examiners already have a quota system, and it's based on their GS level and the technology they examine. As a former examiner, I'm very familiar with the system. But what if each examiner had to issue a percentage of patents based on the total number of examiners, not on a GS level or a technology, but based on the total number of patents? And you could call this maybe a fair share quota. So for example, assume the USPTO has 50 examiners. Then each examiner would need to allow 2% or 1/50th of all the patents to be doing their kind of fair share of the work. If you come from a family of brothers and sisters, you'll understand what doing your fair share of the work is. So to meet their fair share of the quota, an examiner needs to issue 2% of all the patents in this example. So if the examiner is working really hard at allowing patents and exceeds their fair share of the quota, then they issue more than 2%. The examiner is not allowing very many patents for whatever reason, then the examiner is issuing less than the 2% required quota and is not doing their fair share. So that's kind of the concept behind this. Try to how can we visualize these two types of data together? So what we did, let's introduce a metric called a fair share percentage, which is the percentage of U.S. patents issued by an examiner type divided by the percentage of each examiner type. And this fair share percentage is an expression of how each examiner type performs against their fair share quota. Are they issuing their fair share of the number of patents each year? So if the fair share percentage is 100%, then they're meeting the quota. And the examiner is doing their fair share and is allowing patents, as many patents as there are examiners of that type, and the examiner type is meeting the quota. If the value is more than 100%, then the examiner is allowing more patents than there are of that type of examiner, and the examiner type is exceeding their quota. If the examiner type is less than, the value is less than 100%, then the examiner type is allowing less patents than there are of that type of examiner. The examiner type is below their quota. So hopefully it's not too esoteric, but just we're trying to visualize or combine that data together. And so if you look at this data together, what you have is this figure plots this fair share percentage of each examiner type and really helps, we believe, to illustrate the impact of the examiner type on the allowance of the patents. As you can see, the green examiners consistently beat their fair share quota and well exceed the quota by 60% on average. In contrast, the yellow and red examiners consistently do not meet their fair share quota, and the yellow examiners miss their quota by 20% on average. The red examiners miss the quota by 75% on average. So in other words, what this graph really shows is that there's a fewer number of green examiners are allowing disproportionately more U.S. patents, and the greater number of yellow and red examiners are allowing disproportionately less U.S. patents. So you can take this also, and you can look at maybe disposed applications. So the same concept. So with the data we collected, we can also look at the impact of the examiner type on overall dispositions of patent applications. So a disposed application is either a patent application being issued or one that's abandoned in a particular year. This figure illustrates the percentage of disposed U.S. patent applications by examiner type. As you can see here, the percentage of all disposed applications by green examiners is more than those by yellow and red examiners. And over this time period, the percentages of disposed applications by green examiners and yellow examiners has narrowed and is on average around maybe 55% and 45% respectively. Meanwhile, the percentage of disposed applications by red examiners has remained at or below 10% over the time period. So if we kind of take this data and put it through this fair share quota idea, this figure illustrates the fair share percentage of the disposed U.S. patent applications by examiner type. Here, the green examiners again consistently exceeded this quota by approximately 40% on average. And in contrast, the yellow examiners and red examiners are consistently below their quotas of 10% and 50% respectively. So compared to the fair share percentage chart we showed previously on issued patents, the fair share percentages here for the green examiners are a little bit less, and the fair share percentages for yellow and red examiners are a little bit more. So what this change indicates, we believe, is that the amount of abandonments does affect the fair share percentages, but that the green examiners still have a consistently higher throughput of examining applications than the yellow and red examiners, which goes to the thesis of the proposition that the green examiners examine applications quicker. They have a higher throughput than the red examiners, which tend to prolong prosecution, same as yellow examiners. And this graph shows that that throughput can be actually measured, how many applications are going through over the years.
Yeah, and this addresses my earlier question about what looked like a decrease in the amount of patents issued by green examiners. There really isn't. When you look at it in terms of their fair share, it's fairly constant over time.
That's pretty constant over time, right? Pretty constant over time. Yep. And also, this one shows here that their green examiners are handling, about that same volume of applications over time, whether the amounts they're decreased, but compared to what they should be doing, they're actually doing about the same amount, over the time as well. Yellow has increased slightly, and red's kind of bopping around a bit.
Mm-hmm.
Okay. So as I mentioned kind of at the beginning, you can read more about the results presented here. Please check out our Part 1 article in the Law 360 published on May 15th, and the Part 2 article just published earlier this week on June 16th, and it's available as well. Also, I'm happy to take any questions after this webinar. Like many of you, I'm sure a phone call or an email to help break up the sameness of the COVID-19 quarantine is always welcome.
Great. Well, thank you very much, Michael. Megan, I know you've got a couple slides here, and then I've got a couple slides I want to share, and then whatever remaining time, we can try and take some questions. I've been answering some of the questions via direct chat as well. So Megan, you want to take it away?
Yeah, sure. If you can actually skip ahead a few slides,
Sure.
all the way to slide 28, that'd be perfect. Yeah, that's right. Running short on time. So Gene's been alluding to this throughout the discussion. So it's very clear from the data that getting a red examiner is going to be bad for you as an applicant. And once you're already mired in prosecution with a red examiner, sometimes your strategic options are limited. So the best thing that you can do to work with a red examiner is to try to avoid getting assigned to one in the first place. As we've learned from Michael's research, every technology space at the patent office has some combination of red, green, and yellow examiners, but some of them have more red, some of them have more green, and some of them have more yellow. So we tend to think of this concept as a lottery. Like, what's your percent chance of ending up with red, green, or yellow? And what determines this lottery is where your application gets classified when you file it at the U.S. Patent Office. Every time you file your application, it goes off to the classification contractor who looks at it, assigns a USPC code to the claims, looks at the primary USPC code, and that primary USPC code determines which art unit it goes to. And as Gene mentioned, he and I have been on a series of webinars that we'd love for you to listen to that really go into detail in that process so you can understand what happens. But that is probably the most important strategic point in prosecution, because that's determining which lottery you play. And some lotteries look decidedly better than others, and surprisingly different from others. Even art units, that are adjacent can have very different looking lotteries. 2811 and 2812, for example, actually look pretty different from each other. And you can have some level of influence over this. So Gene, I know you have an example that you can go through to show people how you can have an influence on this process.
Yeah, I do, and I have 4 slides to go through really quickly. So if you could just flip over to the next slide, and this is something that I've been working on for a while here now. So if you notice in the IP Watchdog, I haven't really been writing as much as I have been lately, because I've been so focused on this classification stuff that we've been doing these webinars on. It's been fascinating, and then I also stumbled across, as I've been doing this and trying to really understand this and how we can steer things around, I stumbled across this recently issued patent, and it is to a charging station for an electrical vehicle. Now, those of you who are familiar with 101 will recall the charge point decision from the Federal Circuit said that an electrical vehicle charging station is abstract and patent ineligible. So when I was just looking through the Gazette and I found this, I'm like, here's an electrical vehicle charging station that the Patent Office allowed. So let me actually look at the claims. And Megan and I, we're going to be working on a presentation, probably a webinar later on in the summer about this. I'm going to do some articles about this and really detail and break down it here. But this is the claim that was allowed. I have it color coded here so that you can see quickly what in purple, what the preamble is, and then in yellow, what the elements are, and then in blue, what the action is, so that you can just very quickly, without any prior preparation, kind of get an idea of what's going on here. You have a control unit, you have a first hollowed out component, a second hollowed out component, and when they come into alignment, then the charge goes through to the vehicle from a power station through a power transmitter, and then the power is converted to the right frequency, a radio frequency, so that it can actually charge the electrical vehicle. So this was the claim that was allowed. There were no method claims in this patent. Okay, so what I'm about to show you is hypothetical. Okay, it is hypothetical. So if we can move to the next slide, what I did was I wrote hypothetical method claim 1 that fit within the disclosure of this particular patent. Okay, so this was not in the patent. This is what I wrote. And what I did was, I took this claim and I ran it through Pathways, which is a LexisNexis tool that will tell you where are you likely with this claim to be classified. What art unit are you likely to get, and what is the allowance rate for that art unit? And then you can see how many red, yellow, and green examiners make up that particular art unit. So if you wrote this particular method claim with all of that data in it, you know, generating the instruction, radio medium, having a frequency of higher than 500 megahertz, all well supported in the specification, you would do pretty well. You go to either 2800, where you would get an art unit that has an 82% allowance rate, or you would go likely to 3600, where you would get one of the art units that has close to 82% allowance rate. Okay, so then I rewrote this method claim on the next slide to water it down a little bit. Okay, so if we can move to the next slide, notice it's much shorter. Took away a lot of stuff. I thought, okay, well, this is probably going to get us to art unit that is not really desirable. To my surprise, it's still taking us to either 2800, where we're going to have a good allowance rate, or 3600, where we're going to have a good allowance rate, because we're still including the radio medium, a power grid, power transmitter. There's some meat to this method claim, even though it's a bit watered down. All right. So then go to the last slide I have. What this claim is exactly the claim from the previous slide, with only the words added that are in green. So charging an electric vehicle, I added of a user, so that I've had some antecedent basis for what I wanted to add. Billing an account of a user for the power received. So that additional clause, and there's 2 periods here, so I missed that. The period above should be a semicolon. But that additional clause kicks you into the pit of despair. You are now likely to go into one of the business method units at the patent office in 3600, where there are no green examiners. There are only red and yellow examiners. And this is the power of knowing how to draft. And I specifically added that last billing line, because if you go and you look at the charge point decision, the preview here is the specification made a big deal about payment and payment gateways and collecting user information and everything. And it was filed in 2011. And you know, that's pre-Alice, that's even pre-Mayo. So there was no Mayo framework, let alone an Alice Mayo framework. But anytime you're going to talk about billing or payment in your claims, you're going to turn something that otherwise was not a business method into something that becomes a business method. And that's just the way it is. And we can talk about whether it should be that way or not, but it is. And I understand that this claim is more narrow than the claim in the previous slide, but it doesn't matter. If you are claiming anything that smells like you're making money, you're going to be going to a business method art unit, and you're going to get red examiners. I mean, at a 2 or 3 to 1 ratio. Everything else we talked about, you want to stay out of those art units in 3600, and you want to be targeting 2600 and 2800 with your computer claims to the greatest extent possible. So that's what I have, and this is the power of drafting intelligently and smartly, knowing what we know from Michael's research. Megan, did you want to add anything here?
I just want to, in the little time we have left, I just want to mention one other practical implication of the data that we've seen today, because there was a user question about this earlier. It said, okay, so you've done a lot to evaluate examiners, but how do I evaluate law firms or corporations in light of this? And if you go to the next slide, to me, the other big takeaway from this data is that you have to be really careful about how you evaluate law firms and corporations, because their results are very highly dependent on the examiners they were assigned to. So if you take this one example application on the screen, it's filed in 2016, granted within 3 years with 3 office actions and an RCE. This could be a very good result, depending on the examiner you get, or it could actually be an inefficient result, depending on the examiner that you get. If this application were assigned to examiner A, with super high allowance rate, very few office actions to allowance, I would say it's not the best result. You actually did worse than average. And whereas if it was assigned to examiner B, you would think, oh, this was actually a pretty decent result. So I think it's important whenever you're doing an analysis of other prosecution players that you normalize for this. And if you go to 2 slides from here, you'll actually see we've done this in the PatentAdvisor system. So this slide is just showing an example comparison I did of the 5 major players from each geography in Technology Center Group 2120, which is AI and simulation modeling. The y-axis here represents allowance rate, and the x-axis is just the time to allowance. So like efficiency and effectiveness, basically. And what you see is that the US looks like they're doing the best in terms of both efficiency and effectiveness. But if you go to the next slide, what we did was we normalized those efficiency results for examiner difficulty. So we literally scored every single application that these US companies had in this technology space based on the examiner that they were assigned to. And suddenly, when you normalize for examiner difficulty, it paints a very different picture. Now the USA and Europe are on par when it comes to efficiency at the patent office. So I think it's something really important to keep in mind. I know that these statistics are being spread around more and more. People are using them to evaluate law firms, and it can be very misleading if you're not accounting for the extreme examiner variability that we've seen today.
Yeah, and also don't always remember too is when you're evaluating law firms, the easy way to get an allowance is you don't go for the pencil claim. You go for a claim that's a page long too, and that's an allowance. But is that a useful allowance? So there's more that goes into evaluating law firms. So the data gets you some very useful information. It's not that any of this is not useful, but it opens the window into where you need to be looking and gives you real insight. But I don't think it's a thumbs up or a thumbs down on all decision making in and of itself. You have to normalize for it like it's done here. Right, Megan?
Yep, that's exactly right.
Yeah. So the normalization, and that's increasingly becoming more a part of big data is the normalization, because you can do that now with the computing power and the data. So it's knowing what you're trying to look for. It's articulating what you want to know, because you get what you ask for. If you want a law firm that is going to have 100% allowance rate, you can find a law firm that's going to have 100% allowance rate. I mean, that's not easy. That's not difficult to do. But the question is, you want to make sure that you're getting good efficiency, good allowance rate, and good rights. And that's why you need these types of tools to help you figure that out.
Yep. Yeah, and that's why we plot it this way. It's very easy to sacrifice one of those things at the expense of the other. So
right,
make sure that you try to optimize them all.
Right. Well, we've hit the 1 o'clock hour here, so it's probably time for us to sign off. I think you have something on the next slide that you wanted to share, and then we can probably wrap up, right, Megan?
On
slide 30,
yeah.
37.
I just wanted to let people know that the type of analysis that I did for those 3 geographies is something that you can do with PatentAdvisor. You can compare any law firms, any corporations, or any groups of law firms and corporations to each other in the way that we have, and you can normalize for examiner difficulty. So you don't have to worry about that as being a confounding variable.
Oh, wow. So that comes out. I didn't even realize that when we were looking at the slides previously. I missed that this is a table there where it's all broken down. That's pretty cool.
Yeah, we can break it down as well.
That's awesome. Okay, Michael, if you could push to the last slide, that'd be great. And what I'd like to do is, before we leave, I want to give each of you one final opportunity to to give the big picture, if you will, what is it that you would like people to remember as they leave this webinar? The one big thing, Megan.
I'd say the one big thing is to not be discouraged. Yes, there's this variability at the patent office, but knowledge is power. You just need to be aware of it at both, in terms of improving your own prosecution outcomes and in terms of measuring others' prosecution outcomes.
Mm-hmm. And Michael, what one big thing would you like people to leave remembering today?
Maybe we lost Michael.
Did we lose his
Sorry,
audio?
Nope. I'm sorry, I was on mute. Sorry about that. Yeah, so I think thanks, Gene. So I think for today, for today's talk, I think for folks to realize that there is a variability in terms of examiner types of the patent office, that it is distributed uniquely through the patent office. In some cases it's the same, some it's different, but that it does exist. I think as this research further explored, we'll talk about a little bit later, other in the future, is that it actually impacts several metrics in the life cycle of the patent application, which is all pretty exciting as well too. So
yeah, and thanks, Michael. And for me, the one big thing is you need to know that this exists. You need to know that there are green, yellow, red examiners out there, where they are, and then you need to also really appreciate that one phrase in the claim set can really impact where it is that you're going to go, and that will dictate whether you're likely to get a red examiner versus a green examiner. So you need to know where these people are, you need to know who they are, you need to know the impact that they're going to have, and you're going to need to know that what drafting you're going to be able to do in order to avoid them. And you need to be able to explain this in easy to understand terms so your clients can appreciate it, so that they're going to give you the latitude to do what it is that you need to do. So I really would encourage you, if you haven't watched the 2 previous classification webinars we did, I would encourage you to do them. They're incredibly eye-opening stuff that, I'm watched this like a laboratory animal, and there was stuff that came up in those from the people who actually do classification that I was unaware of. And we're going to continue on this push on this series throughout the summer and give more drafting tips, more writing tips. So we hope you will join us throughout the summer as that unfolds. But for today, that's all we have for you. Appreciate you joining us. And Megan, Michael, thank you so much for joining me on the panel.
Thanks, everyone.
thank you.
Have a good day, everybody.